In congressional hearings, two different worlds collide. The first, the world of a federal prosecutor. It is slow and methodical. Every word is chosen to withstand scrutiny by an appellate court. Evidence standards determine what can and cannot be said. Secondly, the world of congressional inquiry. It is fast. Sound bites determine what is important. A trim moment speaks louder than months of legal wrangling. These two worlds clashed head-on the day Special Counsel Jack Smith faced off against Committee Chairman Jim Jordan. Jordan was holding Smith's own deposition statements, and he would read. Cassidy Hutchinson's testimony was second, even third-hand testimony. If I were a defense attorney, I would try to keep it out of the trial because it was hearsay. Smith had said this in his own deposition record. And Jordan would read those words not from a veiled interrogation, but from Smith's mouth. Watch the full video. Because this hearing is a textbook example of the tension between congressional inquiry and legal procedure. But to fully understand this clash, it is necessary to know what each side wants. And these two didn't want the same thing at all. Chapter 1. Two Men, Two Approaches. Jim Jordan, Ohio Republican, chairman of the House Judiciary Committee, a name known for his sharp questioning style in conservative circles. He enters each hearing with the clips he wants to use already clearly in his mind. Jack Smith, a prosecutor with nearly a 30-year career. He has served under both Republican and Democratic administrations. He has conducted war crimes cases within the International Criminal Court. Someone who had been appointed as a special prosecutor, completed their duty, and appeared in court. Smith was ready for the hearings. He was ready with the discipline of federal prosecution. Every sentence would be defensible. Each answer would retain its context. Nothing would be presented out of context, but Jim Jordan was ready with the opposite approach. And all he wanted was simple. Smith reading his own words to him. Chapter 2. Cassidy Hutchinson and June 28, 2022. In 2022, the January 6th Committee held a series of primetime hearings, and on the evening of June 28, 2022, at 8 p.m., former White House aide Cassidy Hutchinson sat alone on the witness stand. This was a conscious visual choice, and her testimony that night dominated news bulletins for weeks. Her most striking claim was that Hutchinson recounted how on January 6th, the then-president lunged at the driver in the vehicle, trying to grab the steering wheel and insisting on going to the Capitol. It was visually powerful and politically extremely heavy. But there was a detail in Hutchinson's own testimony. She hadn't witnessed the incident firsthand. She had heard it from someone. So it was second-hand information. And in the Smith deposition in Jordan's possession, Smith had said exactly that. Chapter 3. The First Trap. Jim Jordan straightforwardly asked, "So, do you think he was lying?" Smith, with a prosecutorial reflex, provided context by stating that the testimony was second-hand, that Hutchinson did not see it herself, and that she heard it from someone else. Jordan pressed on, asking, "Do you know Tony Ornato?" After a brief pause, Smith replied, "Yes." Jordan continued, "The White House Deputy Chief of Operations, right? One of those in the vehicle that day. So what did he say about this claim?" But Smith couldn't remember. Jordan was expecting this. "It didn't happen," he said. He stopped. Then he continued, "Do you know Bobby Engel, the Secret Service agent who was in the car that day? What did he say?" "It didn't happen," he said. And both said they heard this claim for the first time in Hutchinson's primetime testimony. This was a classic cross-examination technique, a technique expected to be used in court, not in the congressional chamber. But Jordan had brought it into the courtroom. If you want to regularly watch these types of political and legal analyses, subscribe to our channel and keep the notifications on. The easiest way not to miss this content is this. Let's continue. Chapter 4. Smith's Deposition Testimony. Jordan looked at the paper in his hand. Jim Jordan said, "Now I will read you something from your deposition statement from last month. I assess that many of Hutchinson's statements are second-hand hearsay. "Did you say this?" he asked. Smith confirmed, "Yes, I said it specifically in the context of what we are discussing now." Jordan continued, "You also said Hutchinson was a second, even third-hand witness for this specific claim." And Smith's response remained unchanged as he confirmed again. And we asked, "If you were the defense attorney, how would you approach Hutchinson if she were on the witness stand?" You answered, "If I were the defense attorney, I would try to prevent it from being used on the grounds that it was based on hearsay." Smith, "Yes, that's correct." Silence. The special prosecutor had stated in his own deposition that the testimony of the most notable witness in the investigation he conducted was of standards that could not be used in the criminal prosecution process. Jordan had read these statements to Smith, and this was making a difference. Chapter 5. Did you still consider using it? Jordan moved on to the next question. When asked, if the case had gone to court, would you have called Hutchinson as a witness? Smith carefully replied, "We hadn't made definitive decisions about who would be called." But Jim Jordan didn't let it slide, saying, "You were still considering it, so you knew it was hearsay, and you acknowledged in your own deposition that it would be legally problematic, but you were still considering using it," and then turned back to the book he was holding. Washington Post reporters Carol Leonig and Aaron Davis wrote a book documenting the investigation in more than 300 pages. On page 310, they write, "Smith had questioned whether some of the allegations could be used in the prosecution. The prosecutors on his team said they did not want to use Hutchinson as a witness in court, and Smith eventually agreed." Jordan, raising his voice but increasing his weight, asked, "Are these writers lying?" Smith resorted to his standard response, "I hadn't made any definitive decisions about who would be called." Smith resorted to his standard response, "I hadn't made any definitive decisions about who would be called." Chapter 6. The number 185. Jordan looked at the notes he had prepared. "Do you know how many times Cassidy Hutchinson appeared in the final report of the January 6th committee?" Smith didn't know. 185 times. Jordan left the number hanging in the air. 185 times. And most of those 185 citations are statements based on hearsay, which a defense attorney could object to in a legal trial, according to your own statement. This was an argument built by Jordan not on anger or accusation, but on arithmetic. 185 citations. Your own words. Non-standard expression. The question raised by this component was clear. If the legal basis of this statement is problematic, why was it made the central figure of a congressional report? Smith was not obliged to answer that question. He didn't write the committee report. But Jordan's framework was blurring this distinction. Chapter 7. Transition to the money matter. Questions shifted from the legal expression issue to the financial aspect of the investigation. In the question, "How much money did you spend investigating Trump?" Smith did not know the figure by heart, but Jim Jordan was expecting it and answered, "We raised $35 million. He answered $35 million and then moved on to a more specific area. "How much of this $35 million did you give to secret human resources?" It was reported last week that 0,000 was paid. How many more are there? Smith explained. He confirmed that the FBI paid a confidential source who examined video and photographic evidence related to the January 6th events. He stated that the use of such confidential sources is a standard practice in FBI procedures. The protection of the source's identity stemmed from security concerns related to the subject of the investigation. Jordan didn't let go. "Why didn't you issue a summons?" "As a special prosecutor, you have the broadest subpoena power. Why did you have to pay the sources?" Before the deadline, Smith tried to explain that the payment was made for a technical service related to evidence review, not for a position where a subpoena could be issued. But the explanation came off as defensive within the framework Jordan had established. Another member of the committee took over the question from Jordan. "Do you know if other special counsels have paid secret sources? Did Robert Mueller do anything like that, to your knowledge?" John Durham? We have heard all these names here. I haven't encountered such an application in any of them. This is the first time I've heard of something like this. Smith said he did not know whether a confidential source was used in other investigations. If you want to follow these kinds of legal and political analyses, don't forget to subscribe to our channel and turn on notifications. We continue with this content. Now let's see what this trial means. Chapter 8. What did both sides want? This question needed an honest answer, and Jim Jordan's goals were clear: to show Smith's own confessions regarding Hutchinson's testimony to the public, to place a statement that the January 6th committee found legally problematic at the center of the primetime hearing, to frame secret source payments as a questionable practice, and to have Smith articulate all of this in his own words. In this respect, Jordan achieved the hearing's purpose, and Smith's deposition was presented to the public. The number 185 was recorded. Smith's goals were different: to preserve the integrity of the investigation, maintaining context after each question, to show that a legal process cannot be reduced to the speed of a congressional inquiry, and to provide as few usable clips as possible. In this regard, it can be said that Smith was relatively successful. His answers remained consistent, he did not fall into serious contradictions, and he maintained his legal framework. Chapter 9. What this trial is really asking. Beneath the surface, this trial represented a clash of two different understandings of accountability. Federal prosecution is based on evidence standards that are resistant to appellate review. A witness's admissibility in court is not proportional to how important they are in a committee statement. A secondary source witness may not be accepted in a legal process, but could be part of the findings of a political investigation. Congressional oversight works differently. Legal evidentiary standards do not apply, and the public interest is defined differently. A committee can even include information in its report that it could not use in court, and the overlap of these two systems makes it difficult to understand both. Jordan's argument was, if this testimony doesn't meet legal standards, why was it presented to the public in prime time? Smith's response was, this investigation was a committee investigation, not my investigation. Mine was a separate legal process, and all standards were evaluated before any final decisions were made in that process. Both positions are consistent within their own framework, but in the courtroom, in front of the cameras, context often falls behind the clip. Chapter 10. What did Smith do? Did it work? To answer this question, it is sufficient to look at what is in the minutes. Smith confirmed that Hutchinson's claim was based on second-hand information. Smith confirmed in his deposition that he said he would have objected to the use of that statement in court if he were the defense attorney. Smith indirectly confirmed that the prosecutors on his team shared similar concerns. All of these admissions contained the clips Jim Jordan wanted, but Smith maintained throughout the hearing, at no point did he declare the entire investigation illegitimate or flawed. He kept his assessment of Hutchinson's testimony specific to a particular claim, and he defended the conduct of the investigation. Both sides got what they wanted as they parted ways. Jordan: Hutchinson's admission, the 185 number, the confidential source question, from Smith. Smith: maintaining the integrity of the investigation, avoiding serious contradictions. On the nature of congressional hearings. This hearing illustrates how layered the accountability debate can be. Jim Jordan conducted an effective interrogation from the perspective of his targets, while Smith managed a difficult position in accordance with legal defense standards and provided consistent, coherent answers, but both addressed the question of truth in different ways, such as which evidence can be advanced under federal law and to what standard. Congress question: which information was shared with the public and how? The answers to these two questions do not always overlap, and this inconsistency is at the heart of why such hearings have been debated for years. Legal scholars will cite this hearing as an example to discuss the limits of congressional oversight. Political analysts will examine the rhetorical techniques in the courtroom. Media observers will analyze what the clips mean. The whole truth is not always within the loudest soundbite. If you have followed this analysis up to this point and want to regularly keep up with content on congressional oversight, legal procedures, and accountability, subscribe to our channel. Keep notifications on. We will continue to share such analysis here. We are curious about your opinions in the comments. How should this tension between congressional hearings and criminal investigations be resolved? See you in the next video.